Welcome to the Division of Aging Case Management Orientation. This is the presentation on Medicaid Basics. Your role as the waiver case manager when it comes to Medicaid is primarily one of advocacy. As the waiver case manager, you're not expected to be an expert on all the ins and outs of Medicaid. The Division of Family Resources, or DFR, is the entity responsible for making Medicaid eligibility determinations. We do not expect you to duplicate all of the knowledge that the DFR caseworkers have when they make those eligibility determinations. However, we expect you to have a little background about the Medicaid eligibility parameters and some of the special rules that apply to waiver clients so that you will be able to act as an advocate for your client and help correct mistakes that may happen in the DFR's eligibility process. One thing to be aware of is that the DFR will require an authorization in order to be able to share information with you. You can get that authorization in a couple different ways. First of all, you can actually be an official, formal, authorized representative for your client, which means you fill out a form with the client, get their signature on there, send that to the DFR indicating that you are an authorized representative for that person. You can act on their behalf when it comes to the DFR, and the DFR can talk to you about anything related to that person's application for Medicaid. That can be an authorized rep just through the initial application process, or it can be an ongoing authorized representative role. You designate that when you first fill out the form. If you're an authorized representative on an ongoing basis, all of the notices about redeterminations or disclosure forms that need to be submitted, bank accounts, whatever communication DFR is sending to the client, you will get a copy of as well. This can sometimes be a helpful role when a client has no other informal supports in place to help them through the Medicaid process, particularly when it comes to redeterminations, where if they don't send in required information, they may lose their Medicaid eligibility and therefore impact their waiver services. So this is sometimes a role you might want to consider taking on. Authorized representatives are designated individuals. They are not designated to a company or organization. So you as the individual case manager are the person being authorized to represent that client. If you don't want to go that route, there's another form that's available that's just an authorization to disclose information. Again, the client fills this out and you can help them with that. It's available from the DFR Medicaid portal website, and they're just authorizing the DFR to release information to you. They specify a time period that's in effect for, and then you're free to contact the DFR by email or phone, and they will be able to share information with you about the client's case. Now, one thing to keep in mind and sometimes remind the DFR of is even though they're not authorized to share information with you if you don't have either of those forms on file with them, that doesn't mean you can't give them information. So if there's something that's been done incorrectly in the eligibility process, or there's some sort of problem the client is having, you ought to be able to contact the DFR, again, by email or phone, and give them information that they can then act on, even if they can't tell you about the action they take. So keep that in mind, that you can still do some advocacy and help the client through the DFR process, even if you can't get information directly from the DFR. So again, Medicaid eligibility is determined by the Division of Family Resources, the DFR, and there are basically two components to the eligibility process. They're looking at income, and then they're looking at resources or assets. So when we talk about income, the regular Medicaid income limit is based on the federal poverty level. So for 2014, monthly income for a single person at the federal poverty level is $973 per month. So if an individual is at or below that income level, they could qualify for regular Medicaid. If they're above that level, they're not going to qualify for Medicaid. For regular Medicaid with regard to assets or resource limits, the limit is $2,000 in assets for a single person or $3,000 for a married couple. Assets are basically any kind of resource asset that can be translated into a cash value, but it does exclude the primary residence and one vehicle for the person. So their home doesn't count towards that asset limit. Their primary vehicle doesn't count towards that asset limit. Personal property, the things you have in your home, furniture and what have you, clothing, that doesn't count towards the asset limit. But all other assets, bank accounts of various kinds, savings account, checking accounts, retirement funds, insurance policies, if they have a cash value, all of those count against the asset or resource limit for Medicaid. Now, so those are the general rules for Medicaid in general. If anybody goes in to apply for Medicaid, those are the standards for income and assets that the DFR will use. There are a couple special rules that apply to individuals who are on a Medicaid waiver program, like the Division of Aging programs, the Aged and Disabled waiver, and the Traumatic Brain Injury waiver. Those rules are referred to as the Spousal Impoverishment Protection Rule, and also the Special Income Limit, or the SIL. With regard to spousal impoverishment protection, it's intended to do exactly what the name says. It's to protect the spouse from impoverishment. And this has been available for nursing facility residents for a long time, where it offered protection to the community spouse who was not in the facility from becoming impoverished and having to reach Medicaid levels themselves because their spouse had to be in the nursing facility. And this is a protection that's available to waiver recipients too, to again protect the non-waiver spouse. One of the primary features of this is when you're looking at income, it allows you to completely disregard the income of the non-waiver spouse. So if the husband is still working and the wife has become disabled and is meeting nursing facility level of care and has therefore been designated for a spot on the aged and disabled waiver, the husband's income doesn't count into that calculation by Medicaid at all. It can be disregarded. Now, when it comes to looking at assets and resources, that is a bit more complicated. Again, just be aware of the process. Just be aware that there is something called spousal impoverishment protection that should be afforded to waiver recipients. The DFR's job is to really sort that out and figure out how much of assets need to be kept in the non-waiver spouse's name and how much can be transferred out of the waiver spouse's name. It's pretty complicated. It's all a matter of timing for when you apply and what your asset limit is at that moment. The most useful piece of information you can know is a number that's called the floor for spousal impoverishment. And in 2014, that number is $24,742. That's called the floor. And so what that means is if your total assets, if the couple's total assets are under the floor, then the non-waiver spouse can keep all of those assets. They'll be given a time frame to get the assets transferred out of the waiver spouse's name so that that's all cleared up by the time any further like annual redeterminations are done. So that really is the most important number to know, because a great majority of the folks we work with in the waiver program will have assets that are below that floor. And so if you know that, then you can get a pretty good idea of whether or not they're going to qualify for Medicaid with the spousal impoverishment protection provision in effect. Beyond that, like I say, it gets a lot more complex about how things are divided between the waiver and the non-waiver spouse. But at least you know it exists, and if the DFR is not applying it, you can alert them to that and advocate for your client. The thing to remember when working with some of the DFR caseworkers is the waiver services are really a very, very small percentage of overall Medicaid cases. And so it's not uncommon to run across some of the DFR caseworkers who may not be really familiar with the special waiver rules like spousal impoverishment. So just being cognizant of that and either offering a reminder to them, asking to speak to a supervisor if necessary, to get someone who knows how to apply these special rules is the best way you can advocate for your client. So the second special rule for waiver recipients is referred to as the SIL, the special income limit. And this raises the monthly income limit that a person can have and still qualify for Medicaid. So we mentioned the $943 earlier. The SIL is measured as 300% of supplemental security income, or SSI. So in 2014, the SSI for a single person is $721 a month. So if we multiply that times 3, that gives us a SIL for waiver recipients in 2014 of $2,163 a month. So as long as the individual's income is below that and they meet the asset guidelines, they could be eligible for Medicaid. Now, just briefly, I want to mention a legal tool called a Miller's Trust. And this comes into play in cases where the waiver recipient's monthly income is actually over that special income limit, the SIL. When that happens, you can get a Miller's Trust document. It's a legal document. It creates a trust. It designates an amount that is to be deposited in the trust each month. The trust document itself can be completed by an attorney, or there are some template forms available on the FSSA website where individuals can create that document for themselves or for their family member. But whether the lawyer does it or the individual does it, it must be submitted to and approved by the DFR before it becomes an official Miller's Trust. But what the trust is doing is taking any amount that's over the special income limit, placing it in this trust account, and then you withdraw the money out of the trust each month to pay the first Medicaid charges that hit. So in the past, we've had something called spend down with Medicaid, where you could spend down to the income limit. This is a little different than that. It's not a pure spend down. It's more like a liability like nursing facility residents have, only this is more of a waiver liability, and it just allows them to spend down to that special income limit. So you have the bank account set up with an automatic deposit. Any amount over the SIL is considered part of that waiver liability or spend down, and that's transferred right into that bank account. And so then when your providers of the Medicaid or Medicaid waiver services bill for their services, the first claims that are sent in, it's totally first in, will be denied until that waiver liability or spend down is satisfied. So that provider will get a denial with a bit of an explanation with it that says you need to bill the client for this amount. So let's say they're $100 over the SIL, and then they'll put $100 into the trust every month. The first $100 that's billed by the providers will be denied. The provider will send the client a bill for $100. The client will pay that $100 out of their Miller's Trust. Now, clients do get a summary notice from Medicaid about the first week of every month that will tell them which providers billed first and therefore had some denials, and then they'll know to expect a bill, if they haven't got one already, from that provider. So if the Miller's Trust is properly set up and constructed, then the money will be deposited and paid out each month, leaving no ongoing balance in the trust. If by some chance there was a balance in the trust at the time of death, it does revert to the state. So that covers the basics of Medicaid as it relates to waiver recipients. We suggest that you take the brief quiz following this presentation to help prepare you for the certification tests later on when you finish all of the components of the online case manager orientation. Thank you.